Have you made one of the common mistakes I see parents make when naming guardians for your kids that could leave them unprotected? Hi, I'm Minnesota Will, Trust, and Estate Planning attorney Chuck Roulette. Over the years, I've worked with hundreds of Minnesota families to help them put a plan in place to legally protect what matters most to them. I've also had the opportunity to speak with thousands of other families, fellow attorneys, and financial professionals from across the U.S. And I frequently see common mistakes parents make when naming guardians for their kids, even if they previously worked with an attorney when preparing their will, trust, or estate plan. Among the many mistakes I've seen them make over the years, two stand out above the rest. The first mistake I commonly see parents make when naming guardians for their kids is not getting it in writing. Even if you take the time to talk to friends or family members about who you would want as the guardians for your children in the event anything ever happens to you, the fact remains that unless you've taken the time to get it in writing, a judge is going to decide who the guardians of your kids will be. And a judge may use criteria that you would not, may appoint someone you would not have wanted, and you could leave your family fighting over guardianship of your kids. The next biggest mistake I see parents make when naming guardians for their kids is naming a couple to act as guardians. Well, you may be thinking, why is this a mistake? Well, it's a mistake if you're not comfortable with the unintended consequences of what you've done. For example, if you name your sister and her husband as the guardians of your children, you've technically named them both. In the future, if they were to ever get divorced, you've now left it up to them, their attorneys, and a divorce court to determine custody. If something should happen to your sister, your brother-in-law is now the sole guardian of your kids. If you would be comfortable with your brother-in-law as the sole guardian of your children, then go ahead and name him. However, if you would not want your brother-in-law as the sole guardian of your kids, then you should only name your sister. If you'd like to learn more about this and other common mistakes I see parents make when naming guardians, and how to avoid those and others, then check out my book, What Happens to Them, What Every Parent Needs to Know About Estate Planning. I hope you found this video helpful, and thanks for watching.